Let's try that all over again. Hello. Sorry for the dead air at the start there. Team, hello there. My name is James. My surname is Dapperchi. I've just poured myself a nice cup of tea. I'm a special counsel, a lawyer at the law firm Chamberlains. And what I'm going to do for the next 45 minutes or so is have a nice chat with you about the law relating to exclusion clauses. And so if you're just settling in with a sandwich or if you're waiting for the bus or whatever it might be, I thought now might be a good opportunity to grab you. We are live on LinkedIn. We are live on Facebook. And we are live on YouTube. So wherever you may be, it's great to have your company. Please feel free to leave comments as we go. Please feel free to ignore the sound of the dog running around on the ground. She'll make scrappity sounds with her paws. And today we are going to talk about the law of exclusion clauses. So thanks for your company. So we are talking about exclusion clauses, and the exclusion clause is going to be a clause in a contract. And the question we have for ourselves is, well, what does the exclusion clause exclude? And that's what we're going to dive into today. Now, I'm a litigator, which means that I'm a court lawyer. I'm not a transactional lawyer who drafts the documents. I'm a court lawyer who argues about them later. So the comments I'm going to make in today's discussion are going to be comments made from that court-facing perspective. So the questions running around my head are what happens when there's a dispute? And hopefully the comments I make about disputes in this area can also inform clients and commercial people, as well as commercial lawyers who are thinking about how these exclusion clauses work. Okay, that is the perspective that informs this paper. Now, it's been said that courts are reluctant to interpret exclusion clauses broadly. They are more likely to prefer to interpret them narrowly. And that is an interesting approach. And I would say it is not the right approach. Rather than saying courts like exclusion clauses that only exclude a few things and dislike exclusion clauses that exclude heaps of things, instead, what we deal with in the law of exclusion clauses is ambiguity. So the basic mechanism when we're looking at how exclusion clauses work is the exclusion clause ambiguous? And it is only if the answer to that question is yes that we march towards this idea of contra preferendum. And if all that sounds like legal mumbo jumbo, don't worry. It's all going to make sense as we work through today's discussion. So as a broad comment, what I say is if you're drafting clauses that contain an element of exclusion, you don't have to sit there and say, make it narrow, courts like it narrow. Your North Star when you're thinking about it should be make it unambiguous. You want to make sure the clause is nice and clear. Okay. So today's talk, we're going to basically get across 5 sort of broad areas. We're going to begin our chat about the why of exclusion clauses. We're going to talk about why they even exist at all. We're going to talk nuts and bolts about the law relating to exclusion clauses. We're then going to talk about some decided cases where the court has had to listen to arguments about what's going on in an exclusion clause case. We're going to have a quick chat about warning signs and the law relating to warning signs. And I'm going to make some practical suggestions for you in your practice, or perhaps you as a client, the things you might want to see in your contract. And my hope is that you find this discussion of value. As we go, can I please extend an open invitation for you to comment away? I can see some of the nice things people are saying on LinkedIn, which is very kind. I've got the stream of comments here on YouTube, LinkedIn, and Facebook going down the right-hand side of my screen. So if you've got comments to make or anything like that, please feel free to make them. Oh, okay. Off we go. No, we don't. Yes, we do. Okay. So as I said, we've divided our talk today up into 5 different sections. And the first such section is the why of exclusion clauses. Why do we have these things? And Dale, thanks for that comment. You're very welcome. The why of exclusion clauses. What are they for? Let's think about what exclusion clauses actually do. They exclude or prevent or stop one party, g'day Lawrence, being liable for the acts of another party. They say, hey, I'm not going to be liable for that stuff. I'll only be liable for this other stuff. Thanks for all these kind comments, team. They're very, very generous. An exclusion clause that says you're only liable for this and I'm going to be liable for that is essentially a tool for allocating risk, right? You're going to accept these risks and I'm going to accept those risks. And when we're thinking about an exclusion clause, talking about the risks that I'll accept and the risks that you're going to accept, it is, as we say, a clause for allocating risk. And it is not some magical, crazy clause that is a breed apart from any other commercial contract. It is very much a commercial term, and it should be treated as such. It didn't descend from on high. The aliens didn't leave it here when they built the pyramids or anything silly like that. It's very, very much a commercial clause that you need to engage with. And I might just offer a blanket thank you for these comments across YouTube and Facebook and LinkedIn. They're very kind. I'll stay on task, but I'm reading them and I'm grateful for them. Now, there are a couple of good reasons for not simply saying, oh, an exclusion clause is a boilerplate, or oh, all contracts have them. We don't need to think much about them. The very, very good reason for you not adopting that attitude is that's not what the court does. And so the judge or judges who are eventually deciding on the exclusion clause you've drafted, I'd suggest to you, you want to have your head in the same space they are going to have their heads when you come before Her Honour or His Honour later in the piece, if it comes that way. But the second point is that your duties as a lawyer and your area of interest as a client are on making sure that every element in your contract reflects the deal you want to make. And so when we're talking about allocating risk, when we're talking about exclusion clauses, when we're talking about who's responsible for what, you are going to need to turn your mind closely in every case to every risk. And for lawyers to do anything less than that is, I say, arguably a breach of your obligations. And for clients and commercial people to do anything less than that is to expose yourself, your employer, your agent, your principal to risk that you may or may not want to expose them to. And so it's important not to simply say, oh, it's just a normal contractual clause, or as lawyers might say, oh, it's just a boilerplate. It's important to engage with what risks are being allocated where. Very, very kind comments here. Thank you, team. Thank you, Dale. That's right. It is important when you're thinking about exclusion clauses, you know, when you're in the distant past, 3 years ago, as it were, drafting the contract, it's worth casting your mind forward to 2023 and what a judge is potentially going to think about what you've drafted. So it's worth bearing these things in mind. So that was a discussion about the why of exclusion clauses, the first of our 5 sections. I'll now turn to a discussion of the law relating to exclusion clauses. And forgive me for a bit of legal chat, technical chat for a moment. When we talk about exclusion clauses, what lawyers often say is, yeah, contra preferendum. I get it. I get contra preferendum. Cheers, Brendan. I get contra preferendum. That's the law of exclusion clauses. And my short response to that is that's a mistake. And I can say that's a mistake because it's a mistake that I've made before, that when advising on an exclusion clause, I've jumped too quickly to that maxim of contra preferendum. And because I'm going to keep using that phrase, I'll just reiterate our definition of contra preferendum. Essentially, and come with me here because it's going to be a bit slow and a bit technical, the rule of contra preferendum is that if there is any doubt about the meaning or the scope of an exclusion clause, so if there's ambiguity about what an exclusion clause means, then that ambiguity will be decided against the party who is attempting to rely on it. So if I'm trying to say, hey, this clause means I don't have to pay, this clause means I don't have to pay, and the clause is ambiguous, then the rule of contra preferendum works against me, and it makes it more likely that I will have to pay. That's the rule of contra preferendum. And I'll just refresh your memory that the rule of contra preferendum is a rule we should not jump to too quickly, because there are a couple of other steps to go through first. Now, the first step when you see an exclusion clause, and perhaps when you've got a dispute looming, is to ask yourself, look, what is the natural and ordinary meaning of these words that I'm drafting, or these words that I'm reading? Because the natural and ordinary meaning is the first step the court's going to take. And so it's the first step that you ought to be taking in the construction of your contract, or in the provision of your advice about a contract. So if you've got a nice, clear, unambiguous meaning, well, then game over. Contra preferendum, contra pref, if we want to be one of the cool kids and say it that way, has no role to play unless the clause is ambiguous. So there's nothing to worry about there until we get ambiguity. So, as I say, let's get our head back in the space of reading this clause or negotiating this clause. We are applying the usual rules of contractual construction or contractual interpretation, and we take the view of, well, what would a reasonable person in the position of the parties taken the contract to mean? And if we have a clear answer to that question, if we have an unambiguous answer to that question, then that's the end of the inquiry, because whatever those parties would have said about that clause, well, that's what it is. End of story. But if we still don't have a firm answer after performing that exercise, then we start moving towards contra preferendum. Sorry, the dog's eating something on the ground. Forgive me. Jake, stop it. What do you mean? She's eating a stick, so that's handy. It's okay. Yes, it's all right. You can keep eating your stick. And so, as we march towards contra preferendum, as we apply these rules of contractual interpretation, Lionel's saying it's contra proferendum. That's it. That's not right, Lionel. Is it, Lionel? If you're going to make that suggestion, I'm going to need you to send some citation in. Contra pref. Lionel, come on now. But let's get back to talking about contra pref, or if I'm wrong, which I don't think I am, contra prof, as Lionel suggests here in the comments on LinkedIn. I'm grateful for the comment in any case, Lionel, so thank you for that. So if we're talking about how do we read this contract, what does it mean, and how do we decide if it's ambiguous, we're going to have a think about, well, what does ambiguous mean? And it's been held by the Supreme Court, sitting in its capacity of the Court of Appeal of New South Wales, that the word ambiguous is itself a word that carries with it ambiguity. So there's complexity there, but helpfully we've got a firm definition coming down from on high from Justice Priestley, as he was then known. Essentially, ambiguity is having more than two plausible meanings. So an ambiguous clause is a clause that doesn't have to be, you can have a 1 paragraph, million word clause. If the meaning is clear, it's got one meaning, fine. It is not ambiguous. So ambiguous doesn't mean complicated. Ambiguous means more than one plausible meaning. It means if you've employed all these tools of contractual construction, you've stared at it 1,000 times, you've thought about what a reasonable bystander in the position of the parties would think about it, and you still say, ugh, there's more than one plausible meaning. That is ambiguity. And so if we are confronted with ambiguity, we then work through more steps on the path to contra preferendum, or if Lionel, our kind commenter on LinkedIn, is right, contra proferendum. So initially, if we're confronted with ambiguity, if we read a clause that has two plausible meanings, the first thought process we go through is we avoid consequences that appear irrational or unjust. If we've got one plausible meaning that says, sorry, examples are not springing to mind for me, and I apologize for that. But in essence, we want to, thank you for these kind comments on LinkedIn, you guys. It's very generous. If we've got a clause that has more than one meaning, if we've got that ambiguity, then we want to avoid the unjust or irrational outcome. So then let's say that we've got an ambiguous clause and we've edited out all the unjust and irrational, they're gone, but we've still got ambiguity. We've still got more than two just, rational meanings. So we've still got ambiguity and we've got rid of the unjust, got rid of the irrational. We then want to get rid of, Dale, this is a great question. Dale kindly asks in a comment made on LinkedIn, does that mean you have to look at it from the other party's point of view? Dale, the short answer to that is yes. So the court is going to look at the various meanings of the clause, and after we get rid of unjust, after we get rid of irrational, we then get rid of any meaning that it is unlikely that the parties would have intended, right? Let's have a think about what we've done. We've got a clause. There's more than one plausible meaning. All unjust meanings, gone. All irrational meanings, gone. All meanings that it is unlikely that the parties intended, gone. And in addition to that, informing those unjust, irrational, unlikely the parties intended meanings, the court will depart from the strictly literal meaning of the words. So the court is able to engage in what might be thought of as a real world approach. And which judge was it? It was a judge in a case called Federico. It was in the High Court in 1986, 160 CLR 513 at page 520. Reference is made to a departure from the strictly literal meaning of a particular expression. And so it is only after finding a clause with more than one plausible meaning, getting rid of all unjust, getting rid of all irrational, getting rid of all unlikely parties would have intended, departing from the strictly literal meaning, and if we've still got more than one plausible meaning of the clause, we then turn to the rule of contra preferendum. Right. By now, we've probably forgot what the rule of contra preferendum is, so I'll just refresh you on that. Remember that contra preferendum is where there is more than one plausible meaning of a clause, of an exclusion clause, the interpretation will be made against, in fact, I'm going to reuse the words I used before, we made against the party seeking to rely on it. So the ambiguity will be resolved against the party seeking to rely on the relevant plausible meaning. The ambiguity resolved against that party. And that ambiguity, remember, must subsist through all those various steps on the path to contra preferendum. Confusing stuff, but hopefully we're now all on top of it. This is the hard bit of the talk, by the way. So if you've survived this far, you're doing well. Congratulations. And just while we're discussing the law of exclusion clauses, I'll just make a quick comment about insurance policies. It's easy for people, including lawyers, to look at insurance policies as some sort of breed apart, some sort of magical area of the law, because there are contract lawyers and there are commercial lawyers and then there are insurance lawyers. And so surely insurance is some other magical form of contract that has all this separate magical stuff going on. The short point is, no, that's wrong. The longer point is that when you are constructing the meaning of an insurance policy, you need to do so on the basis that it is a commercial contract, and you need to apply those rules of commercial construction. Give it a business-like interpretation, as the High Court said in the decision of McCann and Switzerland Insurance 2000 decision 203 Commonwealth Law Reports on page 579. So that was the law of contra preferendum, which is to say the law of exclusion clauses. So today we're covering 5 things: The why of exclusion clauses, we did that. The law of exclusion clauses, we did that. We are now going to come to some litigated examples. What happens when the exclusion clause rubber hits the judicial road? We're going to dive into that now. I'm going to take a sip of tea. I might just pause for a moment to ask a favour. Team, if you're getting any value from this chat, I am a solicitor. My name is James Dappici. I'm a special counsel at a firm called Chamberlains. And Chamberlains, we're good at a number of things. One of those things is we say are putting valuable content out into the marketplace for people to enjoy. So if you want to head to chamberlains.com.au to take a look at some of our areas of expertise and some of the things we've previously published, that would be great. And you are very welcome to do that for so long as this dog allows me to maintain my sanity. Yes, good puppy. Okay. Let us head into our next, our next area for discussion. Okay. Let's have a look at some decisions. The first decision I've got for you is a decision called Santos Coffee and Direct Freight. It's a 2010 decision of the Court of Appeal, New South Wales. What have we got? We've got a coffee manufacturer. We've got a coffee distributor. What we have is our coffee manufacturer manufactures coffee. Our coffee distributor comes in, collects that coffee on pallets, and goes and distributes that coffee. And a deal is made whereby the distributor is obliged to return those pallets in the following week. So in week 1, let's say our distributor takes away 5 pallets of coffee. That distributor is obliged in week 2 to return that same 5. And so there'll be a 1-week delay, and that in essence, the pallets taken in any given week shall be returned in the following week. This arrangement continues over a 3-year period. When the coffee manufacturer comes to review the position and finds that the coffee manufacturer is short over 1,000 pallets. So it's in some tough times. So the coffee manufacturer makes a claim and says, hey, what's going on? Well, we're missing over 1,000 pallets here. You need to account to us for this. Now, let's talk about the contracts, plural, that applied to the relationship. There are 2 contracts that applied. One is what we might call the master contract, and it's the contract in a form that you and I and anyone in commercial practice will be familiar with. Lots of pages, lots of clauses, lots of numbers, lots of confusing words, execution clauses at the end, title pages at the start, all that sort of stuff. That's one contract. The other contract is what I might refer to as a docket contract. So when the distributor comes in and collects a pallet, there's a quick little, collecting pallet 1, this many pallets, click, click, sign. And it's a little carbon copy type rip-off little notepad. So one contract is lots of pages prepared by, in a lawyer's office with signature clauses. The other is a little rip-off docket contract, if I can put it that way. So in our lawyer's contract, or should I say in our long contract, there is a clause that says the distributor shall be discharged from all liability unless suit is brought. Sorry, someone just phoned my phone. Sorry. Hopefully that didn't drop out for you. Hopefully we're still here. Okay. Let me start that again. So, sorry, the lawyer's contract, the long contract, had a clause that might be thought of as the master clause that said the distributor shall be discharged from all liability unless suit is brought within 3 months of delivery. All right, so it says you got to sue within 3 months for any problem in connection with the goods. Right, that's the master agreement in connection with the goods. There's the 3-month issue. Okay. The docket contract says this: no claim for pallets owing by the distributor will be accepted after 90 days. Full stop. So master contract says nothing for 3 months in connection with the goods. Docket contract says no claim for pallets owing after 90 days. Okay, so the issue comes before the court, and the court is asked, well, can a claim be pressed for the entire 3-year period where there are 1,000 pallets missing, or is the coffee manufacturer restricted only to the 90-day period preceding the time they complained? And the court had to turn to the clauses themselves. At first instance, the master contract clause was found to be binding. However, the first instance judge was rolled on appeal, and the court considered this closely and found that they'd erred because in connection with the goods was a phrase with multiple meanings, each of which were plausible. And as you and I now know, that a clause with multiple meanings is ambiguous. And so the ambiguity is going to be resolved contra preferendum. It's going to be resolved against the distributor. Does that make sense? Good. So the master agreement, because it's in connection with the goods, there are multiple plausible meanings of that, which means that there is ambiguity, which means that after going through the path to contra preferendum, all those other contractual construction elements, unjust, irrational, all that sort of stuff, we find that, well, there's still ambiguity, and so it's resolved contra preferendum. The master agreement exclusion doesn't apply to pallets. And so then we turn to the docket contract, if I can put it that way. And the exclusion clause in the docket contract holds because it operates in accordance with its terms. The court says, well, it says no claim for pallets owing will be accepted after 90 days. And it was put by the distributor and it was accepted by the manufacturer. And that's as far as the court's inquiry had to go. And so it was accepted. And so that left the coffee manufacturer in the position where it could only make a claim for pallets based on the previous 90 days. Okay. Let's turn to our second case after I have a sip of tea. And sorry, please feel free to comment or ask questions as I go, guys. I'm keeping an eye on these comments. I'm not answering all of them, and I apologize. A lot of them are very, very nice. So thank you for those. I'm enjoying them. Like any person who publishes videos online, I've got a fragile ego. So saying nice things is always very, very welcome. So thank you kindly for that. So let's turn to the decision of XL Insurance and the BNY Trust Company. It's a New South Wales Court of Appeal decision, 2019, number 215. Okay. Let us have a think about this. Now, BNY stands for the Bank of New York, just for your information. That is the respondent to the appeal. Well, Benjamin Ward asks a very good question. He says, how are you sitting upright, but the door frame is at an angle in this video? I don't quite know. Maybe because it's lower. Does that help? Benjamin, hopefully that helps. I'm sort of at a bench, which is a bit higher. There's the door frame. Oh, hang on. There's the deck outside. I don't quite know, Benjamin. Why don't I put this up here? Then it might make more sense. Let's continue and not get distracted with camera angles, but I appreciate the question, Benjamin, so thank you. We're getting comments on YouTube and comments on Facebook now. This is really, really cool, guys. Thank you. Okay, let's get back to XL Insurance and BNY Trust Company. We have got a lender, and, oh, Damien, thank you for that comment as well. Sorry, we've got a lender who relies on valuations in advancing money, right? The loans are defaulted on. The lender tries and fails to enforce against the borrowers, but fails, and so turns its attention to the valuers. Says, right, well, we couldn't enforce against the borrower. Now we're going to come chasing the valuers to try to get our money back. Now, at first instance, the first instance hearing, first time it came before the court, there was a separate question determination. And the separate question is, look, what is the meaning of this exclusion clause? That's the point we're going to dive into. Now, the clause has some complexity, and I'll apologize for that. The clause says that the insurer will not be liable, right? This is the valuer's insurer, right? The insurer will not be liable to indemnify the valuers, and I'm paraphrasing a bit, for any valuation undertaken for a lender that is not an ADTI, an authorized deposit-taking institution supervised by APRA, unless it has a prudent lender clause in it, right? Let me do that one more time because I really want that settled in your head. The insurance contract that the valuers have says the insurer is not going to be liable unless there's a valuation that is not going to be liable for any valuation where the lender is not an ADTI, an authorized deposit-taking institution, unless there has been a prudent lender clause. Now, you know where I'm going. The lender was not an ADTI, not an authorized deposit-taking institution, supervised by APRA, and the valuation did not have a prudent lender clause. So at first instance, what the trial judge says is, well, it may not have been an ADTI, there may not have been a prudent lender clause, but the absence of those two things didn't really affect the reason the loss was incurred, and so the insurer still has to pay because the loss didn't relate to that stuff, so the insurer still has to pay. Well, how could the trial judge have come to that fairly strange outcome? And I'll tap my nose when I say fairly strange because it was rolled on appeal, just to give away the ending. But what the trial judge says is, look, the exclusion clause refers to APRA and it's retrospective, and APRA has only been in existence for a certain number of years, and this insurance policy purports to reach back before the time APRA existed. So, I mean, it is nonsensical, and I use the word nonsensical very loosely. It was not used in the judgment. It is not a clause that is responsive in a way that would lead the insurer to accept liability, is what I should say. So that's what the primary judge said. And remember, this primary judge was rolled on appeal. Why was the primary judge rolled on appeal? Well, for two big reasons. The purpose of an exclusion clause is, and you remember this because we talked about the why of exclusion clauses, it is to guard against a certain risk profile. It's for me to say to you, hey, you cover these risks, and you to say to me, all right, James, you cover those risks. And that's what an exclusion clause is all about. And so the idea that, so I'll draw that. Let me start that again. The risk allocation issue was covered. So the insurer says, and so the Court of Appeal says, by the idea that I don't want to be in business with someone who's not an ADTI, and I don't want to be in business with someone who's not an ADTI and doesn't use the prudent lender clause. That's how I'm allocating my risk. That's what we've agreed in the contract. That construction, that interpretation of the contract provides certainty to the parties. I know what I'm insured for. You know what you're insuring me for. It means that there's no need to go conduct an inquiry, as the primary judge said at first instance, before being rolled on appeal, that, you know, you don't need to go conduct an inquiry to say, oh, did the exclusion clause matters really lead to the damage? They say, no, there is an exclusion clause. Stuff is excluded if these requirements are not met. The requirements are not met, so the stuff's excluded. Which I say, with respect, is a useful and commercial outcome, and it overcomes the, with respect, surprising first instance decision in this matter. And as I say that with the greatest of respect. All right. So what we can take from that decision is that the exclusion clause was clearly drafted, and that was the end of the inquiry for the Court of Appeal. So there wasn't even any ambiguity for contra preferendum to act on. The Court of Appeal said, well, it says there's no liability if the party's not an ADTI, and if there's no prudent lender clause. Party's not an ADTI, there's no prudent lender clause, game over. And so, with respect, that's a commercial outcome that gives certainty and is of value and assistance. Right. Let's now turn to our next decision, and thank you for all these lovely comments, which are extremely kind and generous as we march on. Oh, I'll ask a favour as we go. Team, I am a lawyer. I practice at a firm called Chamberlains, and part of what we do at Chamberlains is to try to be generous with sharing our knowledge. So we've got a number of resources, and I'd be grateful if you were happy to check out Chamberlains, chamberlains.com.au, to sort of see what we're up to, and there might be some other valuable material there for you to have a look at. All right, can we now turn to Dalby Biorefinery and Allianz? This is a 2019 decision of the full court of the Federal Court at 85. We've got an ethanol producer, and the ethanol producer stores grain in a number of bays at a refinery, and it's going to later convert that grain into fuel, into biofuel. And so following negotiation with the insurer, I'll just emphasize that point, that there was a negotiation that went on, there was an exchange, an insurance policy is entered into. And there are Perils Exclusions. There are certain things the insurer is not going to accept liability for. They are the exclusions that are defined as the Perils Exclusions. So what we find is that the insurer will not be liable, and I'll ask you to cling on to some of this stuff quite tightly, will not be liable for physical loss, destruction, or damage occasioned by or happening through spontaneous combustion, spontaneous fermentation or heating, or any process involving the direct application of heat. Now, you already know what happens next. One morning, heat was detected in one of the refinery's bays. Emergency services attended, and a lot of the grain is found to be badly damaged as a result of this heating. So the manufacturer, the refinery operator, makes a claim on the insurance policy, and the insurer says, no, we've got Perils Exclusions, this is excluded, we're not paying. And so a dispute arises. The manufacturer, the refinery operator, refiner, let's go with refiner. Yeah, okay. Anyone has a comment on how I ought to describe that party better, I'm very open to that. Commences proceedings suing the insurer to say, come on, you got to pay. And the question was referred off to an expert. And essentially the expert was asked, look, what was the reason for the damage to this grain? And the referee concludes the damage was caused by self-heating, but couldn't quite drill down on why that self-heating occurred. Could have been rain, could have been the ambient temperature, could have been a bit of humidity, could have been the condition of the grain when it arrived at the refinery, all these sorts of things. And what the trial judge said, remember this is a Court of Appeal decision, so the court at first instance said, hey, look, the word spontaneous does not apply to the word heating. And that means heating is part of the exclusion, right? And that means the insurer does not have to pay because heating is excluded. Now, what the first instance judge went on to say is that if he's wrong about that, then the phenomenon, as reported by the expert, is rightly understood as spontaneous heating and will be excluded anyway. Now, what the full court of the federal court did, so this was an appeal of that first judge, is say, no, that's wrong. Spontaneous and heating should be joined, because what we're doing here is that sort of quite technical interpretation of what the words mean. So we're constructing the contract, we're interpreting what it means. Spontaneous heating was an exclusion, and spontaneous heating is what happened. And so the insurer doesn't have to pay because that's an exclusion. That's one of the Perils Exclusions that the parties negotiated and agreed the insurer would not have to be responsible for. The full court also agreed with the alternate interpretation of the trial judge that the phenomenon was properly understood as falling within the exclusions. And the full court offers the same counsel that I would encourage you to adopt for yourself in considering clauses like these. Hoodus, what's up? Dale, what's up? Is that we ought to be careful before moving too quickly to contra preferendum, especially when there's evidence that there's been negotiation between the parties. Okay. The final decision we're going to discuss is one that happened in Wales, and it's a decision called Persimmon Homes and Arup. And there's been a suggestion that the rule of contra preferendum has largely fallen away in England and Wales. While that may or may not be right, I think this is a case that's not strictly binding in Australia, but I thought it might be useful in illuminating the Australian position for us. Okay, Persimmon is the builder, is building this great big development in Wales. Arup was an engineer engaged to provide engineering services. There's a contract between the two relating to the provision of those services. And what the contract says, drafted by the engineer, is liability for any claim in relation to asbestos is excluded, right? There is asbestos found on the site, and what the builder says is, hey, this is your fault. And what the engineer says is liability in relation to any claim for asbestos is excluded. It's excluded, my friends. Now, what the builder says is, no, you're not interpreting the contract properly. What the contract means is liability for causing any claim in relation to asbestos is excluded. This doesn't relate to causing of any claim, and so there's no exclusion, and so you've got to pay. And at first instance, the judge said, no, that's wrong. And then on appeal, the judge agreed. The Court of Appeal agreed, saying that formulation would be bizarre and nonsensical, because as the provider of engineering services, it's slightly strange that the thank you for these kind comments. I'm sorry to be distracted by them. It is slightly bizarre that the engineer could be suggested to have caused a claim relating to asbestos. And so the exemption argued for by the engineering company of saying any claim in relation to asbestos and rejecting the builder's characterization of any claim for causing asbestos damage, that was upheld, and the engineer won on both counts. And Lord Justice Jackson, in delivering his judgment, just made a useful comment about exclusion clauses that I might just linger on for a moment here. Exemption clauses, as they describe in the exclusion clauses, are part of the contractual apparatus for distributing risk. There's no need to approach such clauses with horror or with a mindset determined to cut them down. Contractors and consultants who accept large risks will charge for doing so and will no doubt take out appropriate insurance. Contractors and consultants who accept lesser degrees of risk will presumably reflect that by the lower fees that they can charge. So what we see is a very sober and, with respect, very useful characterization of the commercial role that an exclusion clause has to pay. Okay. This talk is in 5 sections. Section 1 was the why of exclusion clauses. We did that. Section 2 was the law of exclusion clauses. We did that. Section 3 was examples of exclusion clauses where the rubber hits the road, and we did that. The next section are my sort of suggestions for what we can do in practice about exclusion clauses. We're going to get into that section now. And I might repeat a disclaimer I made earlier. That disclaimer is I'm a litigator and I'm not a contractual drafts person at heart, which means that the suggestions I'm making come from my experience and my research relating to the litigation end of the exclusion clause stick. And so I'm trying to make some comments here that would assist commercial people and indeed commercial lawyers in the way they approach the allocation of risk so that they can understand what things look like when things go to court. So I hope that perspective informs you. And that is the perspective I bring to some of these practical comments that I hope assist. So the approach to drafting an exclusion clause is the same fundamental approach that any lawyer ought to take to any drafting at all. You get some instructions, you offer some advice, you engage in negotiations, and you accurately record the outcome. That's fine. That's uncontroversial. But there are going to be times where that approach might be informed by the divergence in market power between one party and another. So there might be a stronger party, weaker party, and the strength or weakness between the two might be shown or might be dealt with through an exclusion clause. It's an opportunity for you as a subject matter expert as well to flex your knowledge in the relevant area. So it's a good chance for you if all you do is wharf law and you know everything there is to know about wharves. It's a nice chance for you to be able to say, look, I've advised 3 or 4 wharf clients this month. And what's happening in the wharf industry is that there are risks such as X, Y, and Z. And so why don't we draft our exclusion clause to make sure that blah, 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 blah. So that you're then able to bring more value to your client by being the greatest wharf lawyer going around and showing you know what you're doing. And so I say, not only is an exclusion clause a good opportunity for you to do your job, it's a good opportunity for you to build your practice as well. Right. To add to that general discussion, I'm going to make a few more firm practical suggestions, and they all come back to one central point, which is avoid ambiguity. So remember, the rule isn't make it narrow. The rule isn't courts hate broad. The rule is if it's ambiguous, you're going to start going on that path to contra preferendum, and you might not like the outcome. So you want to end that at the very top. You want to avoid ambiguity. So clearly identify what liability is excluded. Exclusions by implication are unlikely to be effective, so you want to clearly describe it. You might want to think about a fairly clear delineation of who gets what insurance. Blogsy has to get insurance X, James has to get insurance Y. That's a matter to be considered. You want to keep records of these negotiations because there could be an argument about what the contract means. You want to monitor the sector. It almost moves back to the point I made earlier about your subject matter expertise, that you want to make sure that your understanding of the industry is reflected in the way you have drafted your exclusion clause, or if you're a commercial person, in the way that you've instructed your lawyers to go ahead and draft it. So there's a question that is asked sometimes when I have a chat about exclusion clauses, which is, well, how much liability can one limit? And the answer is as much as you want, as much as the other party is prepared to agree to. And so I don't want you to think there's some magic. I don't want you to think the words contra pref or contra preferendum or contra profferendum, as Lionel suggested earlier, turn an exclusion clause into some magical crazy thing. This is a commercial term, and you ought to treat it as commercial, and so it's open for negotiation. How much liability can an exclusion clause limit? As much as you want and as much as the other party to the contract wants. So I'm going to have a very brief aside. We've just done, what have we done? The why of exclusion clauses, the law, examples, some practical suggestions. While I've got you, I am going to ask that you consider heading to chamberlains.com.au, chamberlains.com.au, to see some of the other resources we've got there. We've also got a podcast. So if you're watching this live on YouTube or live on LinkedIn or live on Facebook, and if you can see this microphone plugged to me, so I'm talking to you on Facebook, LinkedIn, YouTube using this microphone that I'm annoyingly tapping for you now. But I am recording for the podcast, tap, 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 using this microphone. And so if you're watching this live and you're interested in a catch-up, please head up to the Chamberlains podcast as well. So look, we are all about being generous with our expertise here at Chamberlains. And I'm trying to get my colleagues to call it Chambos as well. So if you're inclined to call it Chambos, that's helpful too. But perhaps that's another discussion for another day. So as I say, we've talked about the why of exclusion clauses, the law, examples, some practical steps. I might just uphold my promise to have a quick chat about warning signs, because sometimes when I've had clients come in, or when you as a commercial person might be thinking about what you or I might say at first blush looks like an exclusion clause, in fact, what we're talking about is a warning sign. So this is a New South Wales specific chat coming up, but it's going to last about 2 minutes. So if you need to take a look at the relevant legislation in your jurisdiction, that's fine. And I can probably nudge you with a couple of good lawyers at Chamberlains who can help you with that as well. So there's no proactive duty to warn of an obvious risk. But if a risk is obvious, there's no duty to set up a warning sign. Regarding obviousness, warning signs are only useful if they're likely to inform the plaintiff, the person who's hurt, of something that's not already known. Right? If they already know something, warning them about it, there's no additional value to be found there. So a person doesn't owe a duty of care. So a local council or a landowner or whatever it might be doesn't owe a duty of care to another person who engages in a recreational activity and engages in the risk associated with it if the risk was the subject of a risk warning. So you can warn of the risk. And there's been judicial consideration of the obviousness of the risk. And the answer is the obviousness is taken at the time of the injury. So there's a decision called Carey and Lake Macquarie Council that liability lawyers will know better than I do. It's 2007 New South Wales Court of Appeal number 4, where we've got someone riding a bicycle at night time. And there is a bollard, which would have been clearly visible in the day, was not visible at night, and this person riding a bicycle bangs right into it. And so while it might have been a very obvious risk during the day, and so there's no need to warn about it, at nighttime it's not obvious at all because it's dark, so there was a duty to warn at nighttime. And then in the case of Dedera, which a very good liability lawyer named Matthew Gerathy, Gerathy, has done a video about earlier that might interest you. There was an argument about the erection of warning signs regarding a bridge that people jumped off, and someone jumped off the bridge despite warning signs and was injured. And what the court said was that the warning signs were actually reasonable and okay, notwithstanding the fact they did not prevent the injury, notwithstanding the fact they did not stop the risky behavior. If you get instructions in the warning sign area, or if you're thinking about warning signs yourself, it's worth getting real firm advice on this stuff, because I've given a few advices on these and you want to really drill into them and make sure you're right on top of the area. So that brings us to our conclusion. Team, I've been working from some notes here. If you'd like a copy of them, I don't have a particularly big problem with that. Please feel free to DM me or email me or whatever it might be. Please feel free to head to chamberlains.com.au, the website. Please feel free to, on whatever platform, LinkedIn, Facebook, we've got the YouTube channel rolling as well. Please head over to Chamberlains there and hit it with a follow or a like or any social media type stuff. And what I might do is give you a couple of moments to ask any questions while I have a sip of tea. There's nothing standing out. So I might thank you very much for your time, which I really appreciate. And team, this is going to become a regular thing. So for the next little while, I'm going to pop on at 1 p.m. on a Tuesday, and I'm going to chat for an hour-ish about areas of the law. So I really, really hope to see you again. And I'd be grateful as well if you told other people who you think might take value from it. I look forward to chatting soon. I'm going to end the broadcast there. Really appreciate your time and your company. It means a lot to me. Have a great day.